Well, I don't know how this one will ultimately shake out, but right now we are waiting for President Donald Trump's response to Special Counsel Jack Smith's request to gag Trump. On September 15th, Smith asked the federal judge overseeing the 2020 alleged election interference case to restrict Trump from, quote, certain prejudicial extrajudicial statements. In his filing, Special Counsel Jack Smith argues that Trump, quote, has repeatedly and widely disseminated public statements attacking the citizens of the District of Columbia, the court, prosecutors, and prospective witnesses. Through his statements, the defendant threatens to undermine the integrity of these proceedings, end quote. We're still waiting for Trump's response to that gag order. It's due by midnight tonight. Former federal prosecutor and former assistant DA in Cobb County, Georgia, Francey Hakes, and former U.S. Attorney for the Northern District of Alabama, Jay Town, joins me. And Francey, I do find with somewhat the irony is that he's worried, that Jack Smith is worrying about poisoning people against the fairness of the trial here, yet he loads these indictments for whether it's a Democrat or a Republican with all these pictures that are completely unnecessary. Your thoughts?
Well, you're right about that, Greta. And as prosecutors, we called those speaking indictments. And there's a reason for filing a speaking indictment, which is an indictment that lists a whole lot of evidence that isn't necessary to list, because all you have to list are the charges and the elements of the crime and the allegations against the defendant. The speaking indictment is intended to do exactly what you say, and that is to poison the jury pool. And unlike President Trump and probably Bob Menendez, the ordinary defendant has no real defense against that publicly. At least President Trump does, although Jack Smith is trying to gag him. And it is ironic, as you say, that Jack Smith files a speaking indictment listing everything, putting pictures, dirtying up the president and the senator, all while then asking that the president not be allowed to respond to any of it, so that the impression left in prospective juror minds is he's guilty.
Jay, what's wrong with the Attorney General on this? Doesn't he see this, that it's, grossly unfair? I mean, like, to me, it's like, he stands before the microphones in his very soft voice and talks about how things should be fair and everything else. And then they put these indictments together, these pictures, knowing that we're showing them all over all over television, all over every newspaper, and knowing that they cannot be fought until trial.
Yeah, I agree with everything Francey said, and with your read-in, Greta. It is meant to gain a tactical advantage, to sort of create some awe over the expansiveness of the bribery in Senator Menendez's case, or the amount of classified or documents that are national defense related in the Mar-a-Lago case, or really even in the J6 case. So there is meant to be this tactical advantage. Here's the problem that I have with the gag order. One is it's sort of a 19-page whine by Jack Smith. If you want to indict the most famous person on the planet, you really need to just suck it up. But as a prosecutor, as I've prosecuted well over 10,000 defendants in my career, I will tell you this. If the defendant wanted to make fun of the Venira, the potential jurors in my jurisdiction, I would say it louder for the people in the back, President Trump. Tell me how all these potential jurors that are going to come in and seal your fate are awful people who would never give you a fair shake. Say it louder. Say it more often. Instead, Jack Smith wants to shut it down. I just think it's a tactical mistake.
Hey, Francey, about this gag order, we're waiting for the president's team to respond to it. But tell me how this, map this out for me, how the judge decides this, and how the judge decides what the president can say and not say, and what if the judge oversteps it and Jack Smith doesn't like and drags him to court. Tell me tell me what's going to happen.
Well, I think it's really complicated in a case like this. When you have someone running for president who's been president and who is campaigning to become president again, you've got a real First Amendment issue when trying to gag him or restrict him from saying anything at all, including about his own case. So the judge is going to have to look at each and every term, if you will, that Jack Smith has demanded, if the judge decides to gag the president and try to enforce that order. And they'll have someone watching every single minute of every speech and every interview that President Trump gives, and we'll see them running back into court frequently, because I think we can all three agree that President Trump is unlikely to observe the niceties of a gag order in the way that the judge might like. So this is just going to become a fight until trial.
And Jay, if he violates this, if there is a gag order, and if he violates it in the judge's decision, in the judge's mind, then he'll be held in contempt, and then he'll appeal it, right? I mean, what's his path?
Well, yeah, and look, I don't think he would be held in criminal contempt, so there might be a fine or something like that associated with it. And I do think Jack Smith is setting this up for maybe something down the road where she draws a very distant line in the sand, way out, that nobody would possibly cross. And as Francey said, President Trump doesn't really recognize the niceties, and he might approach that line. Jack Smith would then have ammunition later in the future to shut him down, defeat him on some motions. Remember, this gag order came right on the heels of the motion to recuse. So this is another way of saying, not only, Judge, are you fit to serve in this case, but look at all the negative things that he's saying about you in your court and the fairness of this trial. And so they came within 48 hours of one another, and that was by design.
All right, Francey, there's a new filing in the U.S. District Court today, which I can't figure it out, but here's the heading on it. It's called Government's Classified Ex Parte, meaning without the Trump lawyers present, in camera, meaning secretly with the judge, and under seal, meaning the public can't get it, for a protective order pursuant to Section 4 of the Classified Information Procedures Act and Rule 16d1 of the Federal Rules of Criminal Procedure. That's all we got. That's right there is the whole pleading. Can you tell, what is this, Francey? Got any idea?
Yeah, well, CIPA is commonly used in national security cases that have had FISA warrants and other kinds of national security information that requires the lawyers and the parties, everyone in the courtroom, to get national security clearances, top secret, or SCI access. And I think what the filing is saying is that there is national security information, classified information that they are proposing that will be brought as evidence in the trial. And so they're filing this motion to deal with all the procedures, who has to get cleared, how they can handle the documents, and what documents might eventually be let in front of the jury.
Well, I think that there'll be a bigger problem, Jay, if it turns out that there is that a lot of the proceedings in this trial is done under seal or closed courtroom or ex parte. I will tell you, the American people, I suspect, we want an open trial, and I realize national security, but if this judge begins to sort of lock things down, I think the reaction by many people will be one where they register dissent.
Yeah, you want to prosecute the former president of the United States, the current front runner for the Republican nomination, and do it in darkness. That's not going to sit well. CIPA is only invoked. It's only triggered when there is a likelihood that the defense or the government is going to use classified information in the trial as evidence. It has to be relevant. And Francey and I were talking in the digital green room before the show about what it possibly could be. Now, there were about 3 million documents that came from the Secret Service, and they do sometimes classify conversations about or with the President of the United States. So that could be it. But I'm still struggling with how it would be relevant at all.
But that'd be on time. I'm going to take the last one. But that'd be on top of the 12.8 million documents that the government already turned over. So I guess, I don't know if we'll ever see, but it certainly is curious. Francey, Hakes, J-Town, thank you both.
Thanks,
Greta.